Welcome again to our mini video blog series on limitation periods. I'm pleased again to be joined by Ana Romero from Spain, Thomas Ricard from Paris, and Gerben Janson from the Netherlands. Last time we were focusing in on what started the limitation periods and how they could be extended. Now, I'd like to explore with you what happens if something goes wrong and the limitation period expires before court proceedings have started or proceedings have been interrupted. And is there anything that can be done to bring the case back to life? So Gerben, starting with you, if that's happened and you start court proceedings, let's say in a motor case after 3 years that there's not been a notification, or after 5 years in another case, can anything be done to keep that case going, or is it barred?
Well, that's an interesting point of view. It works a bit different in the Netherlands, because first of all, the limitation period can be extended by the consent of the parties. But the funny part is the court itself do not have the discretion to extend the limitation period, but they also cannot invoke the limitation period on its own. So if the opposing party does not invoke the limitation explicitly, then the defense is gone. So I had a case once where the judge was really wanting one party to use the argument, but they didn't mention it at all. So the limitation period was no problem at all because the opposing party didn't invoke the argument.
So the responsible party has to expressly raise it as a defense.
Yes, and the judge cannot use it as an argument on her own. She has to have the argument from the opposing party. So that's an important point.
What's the position in Spain, Anna? If somebody misses the 1 year and there's not been an interruption, is that it for the case, or can it be continued?
So actually, it's the same as in the Netherlands. I mean, you would just need to cross your fingers and hope that the other side doesn't raise the argument of limitation, because it doesn't apply automatically. So the judge will not enter into considering whether the claim is time barred or not if the defendant doesn't raise the issue. So it would just be a matter to hope that the defendant doesn't realize. But before that, we would, definitely explore all potential contacts with the defendant to ensure that we are not missing anything that we can argue that has interrupted the limitation period, because there have been situations where the courts have even accepted telephone conversations as interrupting the limitation period. So they tend to be quite flexible on that. But the situation would be as Gerben just explained in the Netherlands. We will hope for the defendant not to raise that argument, because then it would need to be analyzed by the judge. But otherwise, the judge will not enter to consider whether the claim is time barred or not.
If the defendant does raise it as a defense, can you argue that there was a good reason for the delay in proceedings and ask the court to just use their discretion to let the case carry on?
Unfortunately not, unless you've got evidence, something that shows that there have been communications with the defendant. The judge wouldn't be able to avoid establishing that the claim is time barred. His discretion wouldn't be able to go as far as saying, well, there's a good cause for not having interrupted the limitation period.
I think this just goes to show how careful litigators need to be when acting in foreign law cases, because in England, we have a discretion. With defendant raises limitation as a defence, the courts can be asked to use their discretion, depending on the circumstances of the case, to extend that period, even if limitation has expired. Thomas, is there ever an occasion where 10 years passes by and a case hasn't been brought and extension of limitation is considered in France?
It rarely happens. The two things to know about that would be the following. First, because we've got such a long time limitation, make sure to start the case early enough, because people would probably wait a little bit longer than in Spain or in the Netherlands, and it creates issues when it comes to collecting evidence or demonstrating causation with the index accident. The second aspect, and that's something that is quite specific to France, I think, because it's not the same thing in England. You've got a 10-year limitation, but then if your condition in a personal injury case deteriorates, you've got another 10 years limitation that starts from the moment you're consolidated again. So whether it's the same action or not is a long debate, but basically you've got something starting again and offering you 10 more years with all the evidentiary issues it can create and the headaches for the claimant, for the insurers, and for the lawyers.
Yes, well, we do have a possibility in the Netherlands that it's not reasonable to enforce your right to the limitation period, but you have to come from a very good point of view to try to convince the judge that it's not reasonable to use that 5 years period. That's a very difficult argument to use. It's only when it's really harsh in this case. For example, if it's a very serious injury case, then perhaps a judge would say it's not reasonable, but you preferably do not want to go there.
So don't assume that you'll get it. It's only going to be in exceptional circumstances that a judge will allow that.
Yeah. And what is important, where we always will have a discussion if we have, for example, in a medical malpractice case, when there was, because it's a subjective knowledge, when you were able to have the damages and know who was responsible for that. So that could be up for discussion as well.
Okay. Just moving on to commencement of court proceedings. Now, it was this issue has been highlighted recently about a decision of the English High Court in the case of Pandilla and Inter Salonika. And it's suddenly become potentially quite a pressing issue, depending on how this matter goes on appeal, as to what steps need to be taken under the applicable law to start court proceedings. Now, is it the case in your respective countries that you either have to give the document to the other side and that stops proceedings, or do you have to file a document at court? Do you have to do both? Do you need to do neither? Starting off, Anna, we've spoken about the limitation, but to actually start court proceedings, does a document need to be sent to the court, to the potential tortfeasor, or what do you need to do?
The claim will need to be filed in court, and then it will be the court who will serve the claim against the defendants. So the service has to be done by the court, not by the claimant. The claimant needs to file everything, because the difference also in Spain, which is also quite hard, is that you need to file with the claim all the evidence that you are relying upon. You won't be able to add anything later on except in exceptional circumstances. So all the claim bundle will need to be filed all together in court, and then the court will take care of the service upon the other parties.
So once this court is served, you've done enough.
Exactly, yes.
What's the situation in France, Thomas?
The specificity in France is that you need to go through what we call huissier de justice, a bailiff, which is someone who would instruct to ensure that the service is done. The case is then registered with the court, but the service to the other party is done by the huissier, and that's something that needs to be looked after when it comes to transactional, international cases, cross-border cases, such as the one we're often dealing with.
And what's the state of play in the Netherlands?
Well, we have something similar as in France, because you used to be occupied by the French, and we have a bailiff system as well. We inherited their Code Civil. And if you have a normal procedure, then you would have the paper served, but you shouldn't forget to then send it to the court, because otherwise it's not valid. But we also have another procedure, which is a request procedure. Then when you request something to the court, and then the court will send the opposing party a copy of your request. And that's an important exception, because that's something that is unique in the Netherlands, because we have a legal procedure that is only existing for personal injury cases and fatal cases, because you can request the court to make a decision in a personal injury case. For example, for one point, for example, causation, you can ask the court, okay, can you please make a decision about causation, and then we can move on with the case. And that has helped tremendously here in the Netherlands to speed cases up. We used to take 10 or 15 years, and with this new, it's been around now for 5 years or something, it has speeded up personal injury cases a lot in the Netherlands. And one other advantage is that the legal fees outside of court are also damages that the liable insurer has to pay. But for this court procedure, they have made the same system. So if I file a request at the court, just to say, for example, only for liability or only for causation, then my legal fees are still damages that the liable insurer has to pay. And that is a very good way to pressure the insurer to get moving on.
So is it right in the Netherlands that you don't necessarily have to ask the courts to determine or litigate the whole case? You can ask the court to determine a particular issue, such as causation.
Exactly. Yeah, exactly. Because, and that is a unique for the Netherlands, and they have issued that possibility because, especially because usually you have in personal injury cases, you have 1 or 2 points that are really frustrating the rest of the case. And if you could issue a request for 1 or 2 points of discussion, you can just ask the judge, can you please make a decision about these 2 elements or 1 element? And then they can, and then after that, you can move on with the case. And it works very well here in the Netherlands.
I think that just goes to show what a difference cross-border litigation makes. Although, say, for example, in the courts of England, using the Brussels regulations in Rome 2, you can run a case under Dutch law, but you would not be able to ask the English courts just to determine one particular issue. You couldn't pick and choose. You'd have to run the whole of the case or none of the case. And I think that moves us nicely onto the conclusion, looking at maybe sort of tips or anecdotes that you might have when you've been dealing with English solicitors, or should probably say English and Welsh solicitors, running cross-border cases concerning issues of limitation or just important things that you think that they should know, that you often get asked, or you feel that they should be asking you. Gerben, I'll return to you first.
Well, first of all, what I just told you about the request procedure is something absolutely unknown to the rest of Europe. So that is something people could use if Dutch law is applicable. And the other thing, for example, when it regards to limitation, we have a special regulation for minors. The period of 5 years only starts when they turn 18. So that's also different here, perhaps in the Netherlands than other countries. And one other thing is that we could always just try to pick up the phone and call us to see whether this case is interesting enough to do it in your own court or in the Netherlands with regards to the request procedure, because that really helps the Dutch cases moving on at the moment here.
And Anna, are there special rules for children or those without mental capacity in Spain when it comes to limitation?
Unfortunately not. So that's why my main advice would be to contact a Spanish lawyer as soon as you get the case to make sure that the limitation period is protected, because we won't get hardly any exceptions. There are no exceptions for minors. There are no exceptions for those lacking capacity. You need to find out who your defendant is very quickly, make sure that you got the right defendant to interrupt the limitation period against. You need to also understand whether it is a civil claim or a claim against a public body, because otherwise you may end up interrupting a limitation which is not, it won't be accepted because it's a public institution. Another thing that I usually get, and usually unfortunately is time barred, is claims for outlays for example, travel insurers or health insurers in the UK, because there is no subrogation claim in Spain. So we will need to interrupt the limitation period on behalf of the insurer if you also want to bring a claim for medical expenses or repatriation expenses that have been incurred for the victim. So this will need to be done specifically in the name of the insurer. So there is quite a lot of things to analyze and investigate in order to make sure that you interrupt the limitation period correctly and on time. So my advice would be to get in contact with someone, with a lawyer in Spain that can help you investigate and make sure that that the position of your client is protected.
I think what you've just said goes to emphasize how complex this area of law can be, dealing with cross-border matters, and how important it is to get the right person. So, for example, missing out on subrogated claims, which an English lawyer might assume could be pursued, but in fact, they can't be, and limitation needs to be interrupted individually for all of those parties involved as well, which would be very different from an English perspective. The limitation for minors only starts to run at the age of 18 in English law. Thomas, is there an exception for minors or those without mental capacity in France? And do you have any other tips?
There are exceptions in the sense that in practice, a minor, for the assessment of his medical condition, you would probably wait for him to be, for example, 16 to be able to reach a consolidation. And if it's a protected party, you would need to get sort of guardian involved. And there is also sort of court control on the allocation of damages. The only tip that I have is underlying this whole seminar that we're having. France is, for example, the Badinter law is indemnity oriented. France, contrary to the UK, we don't have the balance of probabilities test. When it comes to damages, Part 36 are some things that we do not know in France, and we are slightly less sophisticated than you in that respect. What I would say, and Auto Temple has been at the very front of that movement, would be to communicate with us as experts when we appear before the UK court. My duty is to the court, but that doesn't prevent me from having a good chat with the solicitor and the barrister to clear the air, and I think that benefits the victim, that benefits the insurance company, that benefits the court, and that's all you're doing at the moment.
Well, I couldn't have put it any better myself. I think the fact that cooperation is so important, not only in litigation, but in associations such as PIOPL, which we're all members of as well, gives us a platform to understand each other's laws, the way things approach, and has enabled us to have this conversation today. So I thank you all. I would not hesitate to recommend all three of my guests today as being very knowledgeable, of course, in their respective areas of law, and absolutely superb when it comes to providing Part 35 evidence as well. So thank you very much, everybody, and I hope we can do this again.